Hello, this is Matt on the Moon Lambo channel. The SEC is refusing to hand over documents that, internal documents, mind you, that would indicate how they came to determine the proper way to classify, from a legal perspective, Bitcoin, Ethereum, and XRP. How is it that they came to conclude that both Bitcoin and Ethereum are not securities, but XRP is? And so the court ordered within the last couple months or so, and I've covered that extensively on this channel, the court ordered the SEC to turn over these internal documents. The SEC has refused to do so, and now, today, June 4th, 2021, we get a document filed by Ripple requesting that the court effectively force them to take action. Ripple is asking for help from the court because the SEC is not doing what it was ordered to. Now, this has legal implications. In fact, as you'll see, it's possible that this whole case can get thrown out if the SEC does not behave properly during the discovery process, which is what we're in right now. And so in this video, I have opinions to share with you from 4 attorneys that are in the XRP community. So none of them having anything to do with Ripple or the SEC. They're just being vocal and sharing their insights, since they have backgrounds, their careers are in law. Which will be very useful to get to the heart of what's going on here, and very interesting as well. So I do want to be clear at the outset, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. And I do want to be clear also at the beginning, it's regarding the importance of these documents, it's crucial. Because Ripple has been claiming, it's one of their strongest defenses, or most important defenses, maybe that's a better way to word it. It really is their fair notice defense, which is this idea that Ripple was certainly doing their best to operate in good faith for the better part of a decade now, the whole time they've existed. Meanwhile, the SEC has not provided sufficient regulatory clarity, and then they're coming knocking on Ripple's door almost a decade after inception of Ripple and XRP, saying, oops, yeah, you did things illegally and you should have known better. And the SEC is claiming that they provided legal guidance, hence fair notice, that what Ripple has done was wrong, and Ripple saying, no, absolutely not, you sure as hell did not. And it's pretty obvious that they did not. But this is important because if Ripple did not receive fair notice, and the court finds that to be the case, this whole case is over. And that's not speculation, that's how the law works. The case is over. And so these internal documents having to do with Bitcoin and Ethereum and XRP, and how the SEC came to classify each of those, these are crucial in determining just how strong this fair notice defense is. And it's very clear that the SEC doesn't want this information to get out. So it's like, what are they hiding, right? And so let's go ahead and jump into this. This is a tweet from attorney James Filan, member of the XRP community. He's the one that initially shared this information on Twitter, first that I saw anyway. And he wrote, SEC versus Ripple. Ripple files motion to compel. SEC refuses to turn over internal Bitcoin, Ethereum, and XRP documents Judge Netburn twice told them to turn over. Not a single document has been produced. Judge Netburn will not be pleased. Here's another tweet. So John Deaton, he actually retweeted that from James Filan, and he chimed in as well. Because it's obviously disgusting what the SEC is doing. They're showing a complete disregard for rule of law here, frankly. And so John Deaton wrote the following, attorney John Deaton. It's difficult to maintain credibility when you ask the court for more time to conduct discovery while at the same time refusing to turn over relevant documents already ordered by the court. Even a patient and courteous judge like Judge Netburn has her limits. And for those of you that missed out, and I did cover this in a recent video, the SEC is requesting additional time. I'm trying to recall now. I think it was 60 days. I apologize if I'm misspeaking, but I think that they requested an extra 60 days, which is really kind of laughable and disgusting at the same time, because they were working on this case for years before they filed it, and they still weren't ready, so they obviously shouldn't have filed it, but that didn't matter. The people that made it happen, in large part, They're no longer here. Some of them are still here, of course. But for instance, Jay Clayton, former SEC chair, he's gone. He doesn't care. He's like, bye, Felicia. I'm out to deal with my flaming hot dumpster garbage fire thing. It's like, it's completely, because how much of a, I almost cursed. There could be chairman's in the background, so I am holding back. But how much of a terrible person, let's say, how much of a terrible person do you have to be to know that what you're filing, putting the case together, not even complete? It's right before Christmas. You know this is going to cause billions of dollars in destruction in XRP markets, and you still filed this damn thing. And then they have the audacity, the SEC now has the audacity to ask for more time. Well, maybe you shouldn't have filed the damn case yet. Like, you should not have filed against Ripple yet. How about that? And so somebody named John responded to John Deaton, so 2 Johns here now, and wrote, is this the SEC's way of forcing the court's hand at extending discovery? And John Deaton responded with the following: very astute observation. The SEC will likely argue that the discovery ordered by the court is overwhelming, and the SEC must pull potentially tens of thousands of emails and documents, review them for privilege, potentially redact some, create a privilege log, etc., and need time. And so I was kind of wondering that as well. So they've said they need time. Maybe this falls in line with that. I'm not really completely sure. But there doesn't seem to be communication of, hey, we're working on this, we're going to get this for you. They're just outright refusing to do it. So I don't know for sure if that's going to, if Judge Netflix is going to seem like, oh, that's right, the parallel SEC, they do just need a little bit more time. They can't even get to Ripple's pertinent request during the discovery process. I don't think that's what's going to happen here. That would be my guess. Somebody else asked John Deaton in response to his initial tweet there, how could they refuse, as in how could the SEC refuse to turn over these documents? Can't the court throw out the entire case if they refuse to show the documents that were ordered? And John Deaton wrote the following: the judge could issue a conditional dismissal. She could rule that the SEC has 15 days or longer or shorter to produce the documents, and if they fail to do so by that day, the case is dismissed with prejudice. I haven't read what was filed, but that's usually what's asked for. And so that part at the end, the case might be dismissed with prejudice. My understanding is that if it's dismissed with prejudice, that you cannot bring the filing again. Without prejudice, I believe that you can. If I'm misspeaking, I could swear I got that from one of the attorneys. If I am misspeaking, just drop. I don't pretend to be perfect about everything. Just let me know in the comment section below. Just spread the information. I'm just trying to share what I do know, and when I'm not 100% certain, I just want to make that clear as well. But I think that is the case. And then there was this from our attorney Arturo Portilla, another member of the XRP community. He also retweeted that tweet from James Filan, and he wrote the following: this whole case keeps backfiring on plaintiffs, of course meaning the SEC. Suing Ripple has to be the most unplanned / reckless enforcement action in the history of the SEC. And then he has this little fake back and forth dialogue. He wrote, SEC, Ripple is committing fraud. Judge, prove it. SEC, we don't have enough evidence, need more time. Ripple, SEC failed to provide clear guidance and discriminated XRP versus Bitcoin and Ethereum. Judge, SEC needs to produce Bitcoin and Ethereum documents. SEC, we don't want to. That's basically how it went down. They're like, nah, we're good. It's like the court's just demanding, yes, you have to procure, you have to present, you have to produce these Bitcoin, Ethereum, XRP documents, and then the SEC comes back and they're like, oh no, we good, we ain't got time for none of that nonsense. Like, they're just not gonna do it, just not even gonna do it. Oh, okay. What a bunch of asshats. That's basically what's happening here, though. Then you got Jeremy Hogan, another attorney within the XRP community, also retweeted what James Filan shared, and he wrote the following. And actually, this is kind of adorable. This is so cute. Jeremy Hogan, attorney Jeremy Hogan, you are so wholesome, because he used the word hell but he like bleeped out part of it. He wrote HE and then 2 asterisks when he clearly meant hell. And look, like, this is a pretty clean channel for the most part. Like, I don't use any hard swear words because there could be Cherenses in the background. There's, I'll say hell and damn and a few others, but it's pretty clean compared to a lot of the other YouTube channels out there. And so it's just totally adorable. He censored the word hell. Jeremy Hogan, you have found your way into the XRP community's heart. So anyway, here's what he wrote though. The legal issues in a discovery battle are pretty boring to me, but what the hell does the SEC not want Ripple to see? And he wrote that in all caps, by the way. And he writes, that has me all sorts of curious. So look, clearly the SEC doesn't want Ripple to see something, right? Right? What else would that be? And we've been kind of wondering this whole time, like, what kind of skeletons does the SEC have in the closet? Because if it comes to pass that, the documents are, they see the light of day, and then you find out the criteria that was used to determine the classification of Bitcoin and Ethereum and XRP, and you find out that criteria, if you look at the criteria, that there's tremendous overlap between, say, Ethereum and XRP, for example. If there's tremendous overlap there, SEC's going to have a bad time. And that's exactly what we're hoping for. And this just makes me wonder even further. And it's the same. That's why Jeremy Hogan wrote what he wrote there. Of course. And then somebody named FL wrote back to Jeremy and said, so what happens if the SEC just flat out refuses to show the documents? And Jeremy wrote the following. A judge can levy monetary sanctions against parties for failure to produce discovery, which, and then he writes in parentheses, which may or may not have happened to me. I will never tell. And finally, a judge can dismiss the lawsuit for egregious violations. And so, look, this could come to an end. Now, I don't think the SEC would let it come. Of course, I don't think so. But either they're going to produce this, or they're going to settle so they don't have to produce this. One of them things going to happen. Okay? And then somebody wrote back named It's Showtime, wrote to Jeremy Hogan and said, is the SEC's continued non-compliance borderlining an egregious violation? And can dismissal based on prejudice, if that's even a thing, be ruled based on the totality of one party's behavior rather than one specific act of non-good faith? Thank you, Jeremy. And Jeremy did respond and wrote, a judge can dismiss a lawsuit with prejudice for discovery violations, but we aren't near that point yet. Right, and so this is the first that I can recall off the top of my head where you've seen the SEC pull this particular shady tactic. Now, there's no shortage of shady SEC tactics, but this particular one I can't recall having seen to this point. So they've always got new stuff to throw out. Lots of twists and turns. It's the M. Night Shyamalan twist. And then here was somebody named Maddie XRP responding to Jeremy and wrote the following. Could the SEC be found in contempt if they refuse to produce documents as instructed by the judge? If they refuse, I see them withdrawing the case. Another very positive defense. All we want is the truth, but the SEC is choosing to deny us all that right. It's so wrong. And then Jeremy Hogan responded, yes, contempt, but it would be called a sanction. A straight refusal to comply with discovery eventually leads to the dismissal of the case if it's egregious. And so there we go. And check out this though. Dismissal of the case on the ground still doesn't provide clarity though, correct? Question mark. And then Jeremy responded with the following: if the judge dismisses with prejudice, it would, but that is very rare. So that is what I was thinking, or I thought I read that. Yeah. So yeah, if dismissed with prejudice, that's it. That's all she wrote, right? Wouldn't mind that happening, frankly. So there we go. The army of asshats continuing to march along. Asshats marching. That's what they sound like. You know that's what they sound like. I guess I'll wrap up there. That's as good a point as any. Let me know what you think in the comment section below. When I don't hear from you, it makes me wonder if I did something wrong and you don't like me anymore. I'm not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.